Well, hello and good morning. Welcome to another of my daily updates regarding the California Board of Psychology hearings coming up on December 29th through the 31st. Again, these are open to the public. Um, I guess I'm not quite sure how they're handling that, so you're going to have to kind of figure out contacting the board and finding out how to watch that through Zoom. It's being conducted online. So today I'm going to be discussing my motion in Limine, and that's to sort of establish an evidentiary standard for the hearings, and the board's opposition to my motion in Limine to establish evidentiary standards. And what I am essentially arguing in my motion in Limine is that psychologists are obligated mandated to follow the APA ethics code, and that's standard 2.04 and 9.01 and 3.04 regarding competence and avoiding harm. We don't have a choice in that, as well as 1.04 and 1.05 on reporting ethical obligations. And again, we don't have a choice on that. And that should be the standard by which the ethical actions of a psychologist should be evaluated. But the board is opposing that. They want to introduce pseudoscience and fabricated pathologies and restrict my ability to rely on the APA ethics code as a defense. So these are posted online because there's a public interest in this issue. So in their opposition to the respondents' motion in Limine seeking evidentiary standards, the California Board of Psychology amazingly argues that the APA ethics code is not relevant, that the DSM-5 is not relevant, and that truth is not relevant. And that final one is extraordinarily interesting, since that's a due process kind of thing having to do with, yes, the truth is relevant to criticisms. And this is not hyperbole by me. You can these documents are online. You can upload them to your AI, and the opposition is full of the legal kind of terminology, but the AI just cuts right through it and gets down to what they're arguing, and that the truth is the truth. This is what they're arguing, and so everyone can read it for themselves. They're posted to my consulting website on the media information page, and they're also described on a blog, my blog, that entitled California BOP says APA Ethics Code, DSM-5, and Truth are irrelevant. So there's the blog on that. How the California Board of Psychology's opposition to a motion in Limine raises serious public interest concerns. And oh my goodness, does it. Because if this is adopted as a standard, then the 1.04 and 1.05 on taking action when we encounter unethical actions by another psychologist become unenforceable. That if we do that and criticize somebody who's in the field, we could face retaliatory board complaints, and we cannot use 1.04 and 1.05 as our defense, which is amazing. And that the truth of our criticism is irrelevant, just because we criticize somebody who doesn't like the fact that we criticize them for being unethical and violating ethical standards. And so this is an amazing position taken by the California Board of Psychology, whose obligation is to protect the citizens of California, not these self-identified, self-asserted experts in made-up fabricated pathology. but they're protecting them at the expense of protecting the citizens of California who are being harmed by them because of their unethical practice. Can we all say regulatory capture, Stigler? And I know that because I have background in community psychology, and it's pretty obvious when I got over here that the issue is the state licensing boards are not enforcing ethical standards in the family courts. They enforce them everywhere else, but in the family courts, there's no enforcement of ethical standards. Everybody can just do what they want. It's a free-for-all. With this experiment being conducted on human subjects without IRB approval, without a risk-benefit analysis, and without protections for a vulnerable population, in violation of all three principles of the Belmont Report. It's bad in the family courts, really bad. So this is institutional betrayal trauma that's going on in the family courts. And this is for all the now adult children and parents who lost their children through 40 years in the family courts. And the definition of institutional betrayal trauma by Freud, F-R-E-Y-D, is institutional betrayal occurs when an institution fails to protect those who depend upon it, responds inadequately to reports of harm, or actively enables or perpetuates harm. Here's some quotes by Freud. Institutional betrayal occurs when institutions people depend on for safety and well-being fail to protect them or engage in actions that harm them. Notice it's in the Journal of Traumatic Stress. This is a trauma pathology, the institutional betrayal trauma. Institutional betrayal includes acts of omission and commission by an institution that betray the trust of those dependent on the institution. Institutions often respond to reports of wrongdoing in ways that silence victims, protect the institution's reputation, and perpetuate harm. Regulatory capture. This was described by George Stigler, who's a Nobel Prize winning economist. And the definition of regulatory capture occurs when the regulatory agency becomes dominated by the industry it is supposed to regulate, prioritizing the interests of regulated professionals over the public. Stigler, as a rule, regulation is acquired by the industry and is designed and operated primarily for its benefit. Regulation is not directed at the protection of the public, but at the protection of the regulated industry. So this particular matter before the California Board of Psychology, and let me pull this up, and the response to the motion in Limine, the opposition by the California Board of Psychology that says the APA ethics code is irrelevant, that the DSM-5 established knowledge 2.04 is irrelevant, and that truth is irrelevant, needs to be reviewed by the regulatory system for the California Board of Psychology, which is the legislature. I don't believe the legislature's intent was for the California Board of Psychology to advocate for pseudoscience and advocate for fabricated pathology and rule out protections for parents afforded to and children afforded to by them or to them by the APA Ethics Code Standard 2.04, established knowledge, 3.04, avoiding harm, and to sanction psychologists who are required and responding to their ethical obligations under 1.04 and 1.05 to report and take action further action appropriate to the situation when they encounter unethical activity. I believe that the intent of the legislature is to establish a board of psychology that protects the citizens of the state of California from unethical practices by the psychologists. Okay, but since the board is refusing to accept a discharge of duty to protect in 1.05 reporting and is seeking to sanction the whistleblower, sanction the person bringing this unethical practice to their attention in support of the industry rather than protecting the public, then I believe this requires the next higher order level of institutional oversight, which is the California state legislature, as to whether or not that was their intent. There are 4 oversight committees in the California state legislature, 2 in the Assembly and 2 in the Senate. The 2 judiciary committees have oversight of the courts, and so they'll want to know that or evaluate whether the California Board of Psychology is degrading the quality of information available to the court for its decision making by failing to enforce 2.04 and 2.01 and 9.01 and 3.04 of the APA Ethics Code for families who are involved in the courts. And the two business committees have oversight of the licensing boards. And I'm confident they'll want to review the board's position that the APA Ethics Code is irrelevant, that the DSM-5 established knowledge 2.04 is irrelevant, and that truth is irrelevant, and that standards 1.04 and 1.05 are also irrelevant. They're not allowed as defenses for the conduct of psychologists who encounter unethical activity. So we have the Assembly Judiciary Committee, the Senate Judiciary Committee, the Assembly Business and Professions Committee, and the Senate Business Committee. So here is my documented expertise. Okay, this is me. Okay, so this is the person who is responding to my 1.04 and 1.05 obligations. So this is the person who the California Board of Psychology is seeking to sanction because I was critical, rightly so, truthfully so, of these self-proclaimed experts in this fabricated pathology of parental alienation, okay, required by my 1.04 and 1.05 obligations. So I'm the one with the documented expertise that they are simply disregarding and in support of these fabricated or self-proclaimed experts. So my expertise, and it's not just competence. I want everybody to understand this. This is not Dr. Childress is competent in these domains. Dr. Childress is an expert in all of these domains, relevant domains. So let's take a look at that. So first off, attachment. A child rejecting a parent is an attachment pathology. It's a problem in the love and bonding system of the brain. I have early childhood mental health specialization, which is directly relevant to the attachment system. That's when the attachment system forms. And so I was trained at CHLA by an attachment expert, a recognized expert, Marie Polson, who has a rotation or had a rotation at CHLA on early childhood mental health, which was my internship and postdoc. I know 2 additional diagnostic systems for early childhood. I know 2 attachment treatments for early childhood, Watch, Wait, and Wonder and Circle of Security. And I have infant mental health certification. And infancy is directly spot on when the attachment system gets going. I have expertise, documented expertise in the attachment system. A child rejecting a parent is an attachment pathology. It's a disorganized attachment, i.e., no organized strategy to bond to a parent. The cause of disorganized attachment is either abusive parenting or psychotic range parenting. So all children in the family courts who are showing a rejection of a parent need a proper risk assessment for possible child abuse to the appropriate diagnoses for each parent. Not parental alienation. We are not talking about that. We are talking about real things. Child abuse. Delusional thought disorders. I have advanced expertise in that. I have 12 years of annual diagnostic training in the assessment of delusional thought disorders to 90% diagnostic reliability to a gold standard of Dr. Ventura and Dr. Lukoff, who are the co-authors of the Expanded Brief Psychiatric Rating Scale, one of the oldest, most widely used scales for measuring psychotic symptoms. And I am trained to 90% reliability, diagnostic to them, the top experts, and over 12 years training on that. I am one of the best trained psychologists on the planet in identifying delusional thought disorders. Child abuse and complex trauma. I was the clinical director for a 3-university assessment and treatment center for CPS referred children. Child Protective Services sent their children in foster care to us for diagnosis and treatment. And I'm not just working at the clinic. I am the clinical director of a multidisciplinary team that includes occupational therapy from Loma Linda and speech and language out of the University of Redlands, with psychology coming out of Cal State. And I'm the clinical director of a child abuse treatment center. IRB, Institutional Review Board, and the Belmont Report for human subjects. I was an invited consultant to OPRR, the Office of Protection from Research Risks, now renamed the Office for Human Research Protection, OHRP, and the American Association for the Advancement of Science. Now, the OPRR is responsible for all the IRBs at all the universities and all the clinical settings and things, and providing standards to them for how to evaluate research. Okay, so I was an invited consultant to the oversight institution for all the IRBs. I know what's required. I know what the Belmont Report is. I have the expertise to identify research experiments on human subjects that are being conducted without IRB review in violation of Standard 8.01 of the APA Ethics Code. We need to get oversight into the family courts. And I have community psychology background. I am trained for my master's degree in community clinical psychology. Let me tell you the relevance of that. We talked about institutional capture and institutional betrayal trauma. Community psychology, that's what it does. It looks at how the community and the pathology are interacting and what sort of community interventions are needed or can support the treatment of pathology. And so I have direct training on the regulatory capture issues and institutional betrayal issues that are at the core of what's going on in the family courts. I have the direct expertise, not competence, expertise in the relevant domains. And the APA, the California Board of Psychology, is seeking to sanction me and silence me in favor of self-proclaimed experts in this fabricated pathology who are in violation of 2.04, 2.01, 9.01, and 3.04, and are intentionally withholding the DSM-5 diagnosis from the public so that they can promote their fabricated pathology for their own benefit. Regulatory capture and institutional betrayal. Parental alienation. I want to exclude that from this hearing. I don't want this hearing to be about parental alienation because it's a made up thing. It doesn't meet evidentiary standards of 2.04 and 9.01 that I am required to meet in my professional practice. It doesn't meet that criteria. So let's move it aside because it's going to distort the hearing. It's going to confuse the administrative law judge into thinking that this made up fabricated pathology is actually a real thing. And what parental alienation actually does, the harm it does, is it hides the real thing. It hides the fact that we are not talking about parental alienation. We are talking about child abuse, child psychological abuse. It's in the DSM-5, V995.51. It's a real thing. It hides the fact that this is a shared persecutory delusion. DSM-5, D297.1, a real thing. It hides the fact that this is a factitious disorder imposed on another. DSM-5, 300.19. It hides the fact that this is spousal psychological abuse. DSM-5, V995.87. And so it's hiding child abuse, it's hiding spousal abuse, and it's hiding two major psychiatric disorders whenever it's used. And so promoting this to the general public, promoting this to the courts, promoting this to other mental health professionals is harming them by hiding the actual diagnoses and harming the court by giving the court degraded quality of mental health information rather than actual information about child abuse and spousal abuse, harm, real things. And so we need to establish for any hearing on the ethical obligations of Dr. Childress in this, we need to establish that the APA ethics code applies. But the Board of Psychology says no, the APA ethics code does not apply to Dr. Childress in fulfilling his mandatory obligations. So we got it's hiding real pathology. In addition, the use of parental alienation hides the ethical violations of 2.04, reliance on established knowledge, the DSM-5, 2.01, boundaries of competence of knowing attachment pathology, family systems, delusional disorders, personality disorders, child abuse, and complex trauma. All of those required competence. You don't need to be competent in those if you're using parental alienation, these made up fabricated pathology labels. So it's hiding the ethical violations. And it's hiding the regulatory capture of the APA and state licensing boards by the forensic custody evaluators who are in those ethical violations. Because as long as they use parental alienation, then the regulatory agencies allow them to get away with that without establishing the baseline of 2.04 because it's in violation of 2.04. Parental alienation is in violation of standard 2.04, requiring the use of established scientific and professional knowledge. That's the DSM-5, that's attachment, that's family systems, that's child abuse and complex trauma, that's personality disorders. It's also hiding the institutional betrayal trauma of the now adult children and their parents, because once we apply the established scientific and professional knowledge, 2.04 and 2.01, we realize that, oh my goodness, there's no application of the APA ethics code in the family courts. These families have been abandoned to pseudoscience and to unethical practice, and there is no enforcement of ethical standards in the family courts, because we have violations of 2.01, boundaries of competence, 2.04, established knowledge, 9.01, bases for assessment, and 3.04, of avoiding harm. 4 ethical violations right off the top in all cases in the family courts. But it's being hidden because of this made-up pathology label. The moment we apply established knowledge, who's responsible for enforcing ethical standards? The licensing boards. Where are they? Institutional betrayal trauma, trauma, trauma for the now adult children and their parents who lost their children. That's significant. I am a trauma psychologist out of child abuse and foster care. I know trauma. We have hundreds of thousands over 40 years of traumatized children and traumatized parents who have gone through the family courts, and it's just being ignored. It's absolutely being ignored. We need to get services into these parents and children who have been traumatized by the unethical practices of the psychologists. And professional psychology has an obligation to the children, to their parents, and to the courts to get the highest quality of information to the court for its decision making around the child. The court's decisions are going to have a massive impact on the child. And it's in the context of possible child abuse by one parent or the other. We need to get the court the highest quality of mental health information. That means DSM-5 at the baseline. That means attachment. That means delusional thought disorders. That means child abuse and complex trauma. That means family systems. That means personality disorders. That's the information that we need to be relying on, and that the court needs to be relying on for its opinions. And we mental health, the mental health industry profession, is failing to meet that obligation to the children who are in child abuse, to the parents who are suffering from spousal abuse, and it's a brutal form of spousal abuse. Oh my God, you take somebody's child away? That's a brutal form of spousal abuse. It creates what's called traumatic grief. I know that too. That's a real thing, traumatic grief. That I first ran into that, traumatic grief, when I was working at Children's Hospital on the spina bifida rotation. That's the birth defect that creates the kids in wheelchairs and stuff of the spine. And that the parents there, the traumatic grief, they're grieving the child they imagined, but they still have a child. So it's unresolved grief. It's grief that cannot be resolved. And that's what we have in all these parents who lost their children through no fault of their own. They're normal range, loving, healthy parents, but because of the inverted systems and the failure to apply established knowledge, they had their kids taken from them. And then the children are left in this world that's of a delusion and factitious disorder, and they're just thrown out into adulthood to figure it out on their own. We need to get back into these families and help them recover from the betrayal trauma, the institutional betrayal trauma that they've experienced. And the first step to that is for the institutions to acknowledge what happened. The first step to that is to put a moratorium on the experiment of these forensic custody evaluations and get back to established knowledge. Doctors diagnose and treat pathology. We don't advise the court on custody. That's the court's decision. There's no quasi-judicial role for doctors. Doctors diagnose and treat. That was an experiment on human subjects without IRB, without risk-benefit analysis, and without protections for a vulnerable population. It needs to stop. New York Blue Ribbon Commission, the only institutional oversight that has ever been done with forensic custody evaluations, found that they are, quote, dangerous, quote, harmful to children, and lack scientific and legal value, quote, produce defective reports with potentially disastrous consequences for parents and children. Why are they being allowed? regulatory capture. The obligation of state licensing boards is to protect the citizens of the state from unethical practices by the psychologists. When we have practices by the psychologists that are deemed dangerous, harmful to children, lack scientific and legal value, and have potentially disastrous consequences for parents and children, we need to put a moratorium on that activity until we get more professional eyes on this. That's an IRB review, Institutional Review Board. And for this experimental quasi-judicial role and this experimental assessment procedure of custody evaluations, and at the same time, they are withholding diagnostic assessments and offering the courts and children and parents only the experimental forensic custody evaluation approach. Parents, the children, and the courts cannot get a diagnostic assessment to the DSM-5. It's impossible because no one's conducting that. The mental health services we are giving to the children, parents, and courts are only these experiments. We need to put a stop on that and get regulatory oversight on this regarding what's happening in the family courts. I'm a child abuse trauma psychologist. You look at my vita. I didn't start in the family courts. This is not where I wanted to be. I come out of child abuse and foster care. And so when I enter this situation, I am in a well-positioned place with my background knowledge to recognize the abuse and the regulatory capture and the ethical violations here. Now, there's a characteristic symptom of abuse trauma, child abuse, spousal abuse trauma. It's very characteristic. It isolates its victim from reporting and rescue. You think about the spousal abuse victim, that husband that's beaten his wife, he isolates her from her social group, from other things, so where she can't report and can't receive rescue. You think about the sex abuser. He isolates that little child from the other family members or from other people so that the child cannot report. It's an isolation of the victim from reporting and rescue. So whenever you're a psychologist, a trauma psychologist who knows child abuse, and you encounter a situation of an isolated child, and the child's acting out in some way, or they got something, and that child's isolated, you want to break that isolation, which is what I am doing. This is exactly the treatment for that isolation of the parents and children in the family courts. Exactly what's happening to them. They've been isolated by these forensic custody evaluation experiments. We need to get them back into established healthcare, back into established psychology of diagnosis and treatment based on established knowledge, 2.04 of the DSM-5, attachment, delusional thought disorders, family systems, various things. And so that's the situation in the family courts. So to conclude, not yet, but the APA ethics code is mandatory. It's not optional. It is required. It is mandatory for me, for them, for everybody. And this belief system that somehow it's optional, 2.04 is optional, 2.01 is optional. No, it's mandatory, as well as 1.05 is mandatory and 1.04. And a psychologist encounters ethical violations by other psychologists, as well as 3.04, avoiding harm, is mandatory for a psychologist. So I don't have a choice. Here's what it says. When psychologists believe there may have been an ethical violation by another psychologist. So let me point out how low that criteria is. I don't have to prove the ethical violation. I simply have to believe there may have been an ethical violation, and that activates my required mandatory obligations under 1.05 and then under 1.04 for informal resolution, and then 1.05 for broader notification. Informal resolution on the parental alienation experts. I've known Dr. Burnett since 2011. I've had 2 direct conversations with Dr. Burnett, witnessed by Dorsey Pruder. I have an eyewitness to both of those conversations where I said, Dr. Burnett, you need to switch to the DSM-5. It's already in the DSM-5. And he's trying to promote to parents and everybody that we need to get this parental alienation in the DSM-5. No, it's in the DSM-5 if you just apply it. There's a now adult child out there who is recovering from the institutional betrayal trauma and is reorienting to what actually happened. And she was on my Facebook page arguing with me about parental alienation. And I said, there's no such thing as parental alienation. We need to stay. But she's promoting for these self-proclaimed experts. She's promoting them as supposedly experts. That they've distorted and captured the parents and children. And as they come into the family courts, they're out there advocating for their made up pathology label and withholding from them the actual DSM diagnoses, the delusional thought disorder, the factitious disorder. It's already in the DSM-5, and getting them to believe it's not in the DSM-5 when it is. And Dr. Burnett's known this since 2013. We've got a document. He's known it the whole time. But since 2013, we've got it documented because he sent an email around to everybody with the DSM-5 in the study. And I was on the email at that time, and he says it's not in the DSM-5 and they've rejected it, but it's there in spirit. He just doesn't take no for an answer. No, the APA said no, it's not a real thing. And he says it's there in spirit. And then he lists the actual diagnoses: a delusional thought disorder, factitious disorder imposed on another, and child psychological abuse. He knows what it is in the DSM-5. He's just not telling people because he wants to promote this parental alienation and this old little collective as being experts in this. And he gets away with it because there's no oversight. There's no standard ethical application of standards within the family courts. So when I believe there may have been an ethical violation by another psychologist, there may have been, I am required to, quote, take further action appropriate to the situation. Now, it doesn't say consider appropriate action. It doesn't say you may take no, this is a requirement. This is mandatory. I must take further action appropriate to the situation. What's appropriate to the situation when we have regulatory capture of the state licensing boards and institutional capture of the APA and the AFCC that is in with the context of this, so that there's no reporting avenue for the ethical violations? So that's been my career over the last 15 years, and it's all documented up. I notified the APA the AFCC in 2017 at their national convention. I've got the slides that I have that's an exhibit. I notified the American Psychological Association Ethics Board with a petition to the APA signed by 19,000 parents, hand delivered to the APA. What's been their response in 2018 Nothing. No, they don't care about 19,000 parents documenting that this is a real pathology, not parental alienation. That's the first part of the petition. Documenting the ethical concerns, 2.01, 2.04, 9.01, 3.04, documenting that. What's been their response? Nothing. That's the institutional betrayal. They should be involved. 2025, I have 6 forensic psychologists in violation of 2.04, 2.01, 9.01, 3.04. My mandate, take further action. It says notify a state national licensing board. I did. The APA Ethics Committee. You know what they said? We don't review that until the licensing boards do. So it's back over to the licensing boards. What does the licensing board do? We don't care about the ethics code. We don't care about the DSM-5 and established knowledge. And we don't care about the truth. We only care that you're criticizing pseudoscience. You're criticizing people who are in violation of 2.01, 2.04, 9.01, and 3.04. Don't criticize them. This situation, what's appropriate to that situation? I've documented it. I've even consulted with an ethics specialist, an attorney and psychologist in 2020, Eric Strom. He specializes in consulting on ethical issues with mental health professionals. I sought out his consultation exactly about this situation, and I've got the email to prove that and consultations on that. And yet still, the board is trying to sanction me. Can we say regulatory capture? Can we say we need the oversight from the California state legislature? We need media taking a look at this. Why is this situation happening? Because we need to break that isolation. Abuse pathology isolates its victim. We need to break that out and get attention, get light into the darkness of trauma and child abuse and spousal abuse going on in the family courts daily, today, right now, everywhere, and for the last 40 years. So I am required to take further action appropriate to the situation when, quote, an apparent ethical violation, it doesn't have to be proven, an apparent ethical violation has substantially harmed or is likely to substantially harm a person. Okay, so again, that is not optional. I am required, mandatory, and the California Board of Psychology says that's not relevant. APA Ethics Code 1.04 and 1.05 are not relevant to evaluating your actions because you criticized pseudoscience and these self-proclaimed experts in fabricated pathology pursuant to your required obligations under 1.04 and 1.05. So this is my settlement counter proposal. And this is another talk, and all these are up there, and everybody can upload them to your AIs and see what's going on. So my settlement counter proposal to the Board of Psychology was to accept my discharge of duty to protect. So now I have a direct line into the Board of Psychology to discharge my duty to protect that I have held for 15 years without a location to discharge it. Let me say something about that too. I cannot discharge my duty to protect. I come out of child abuse. Remember that. I cannot discharge my duty to protect until somebody receives it. I need somebody to accept my discharge. Otherwise, I continue to hold it. And who's the appropriate people to discharge a duty to protect to? State licensing boards. So now in this context, I have a way directly into the state licensing board. So I discharged my duty to protect to them. And I said, here it is, Appendix A to the settlement counter proposal. They have refused to accept the discharge of my duty to protect the citizens of California. I'm telling you, California state legislature needs to look and at what the licensing board's values are and help them reorient that their obligation is to the citizens of California, not to these made-up, fabricated experts in made-up pathology labels. So when the state licensing board refuses to receive the discharge of a psychologist's duty to protect and standard 1.05 mandatory reporting obligations when directly notified, this demonstrates the regulatory capture Stigler, and I continue to hold a duty to protect and mandatory 1.05 obligations that must now be discharged into the documented record and through subsequent actions appropriate to the situation. Believe me, I want to discharge my duty to protect. I don't particularly want to be in the family courts. I have early childhood mental health specialization. I want to be working with our wee ones who are having trauma or difficulties, and I want to be working 0 to 5. I want to get into AI psychology and AI safety. Okay, I don't want to be in the family courts, but I have to be because I have a duty to protect the children and their parents from child abuse. And I have a duty to the court to get the court high quality information for the children being abused and their parents who are being abused. So I don't have a choice on this. Standards 2.04, 2.01, 9.01, 3.04, 1.04, and 1.05 are mandatory, not optional. And everybody needs to get off of this idea that ethical standards are somehow discretionary. They're not. Okay. And we need to get baseline established ethics and baseline established knowledge into the family courts and into these children and parents and the courts. I'm dealing all the time with parents trying to find somebody to diagnose and treat their family. They can't find it. They're having to go out to DBT therapists and trying to recruit back for the borderline version, or spousal abuse parent therapists and trying to recruit into the family courts for the narcissistic version, because the custody evaluators, the psychologists who work in the family courts, don't provide the parents and children in courts with a diagnostic assessment and treatment plans that fix things. They just withhold that from the courts. So now the parents have to go, and the mental health people in the courts are so ignorant, 2.01 violation, that the parents are having to explain the pathology to the doctors. You know how bad that is when the patient is explaining the pathology to the doctor and how to assess for it? That's like you go into I'm worried about cancer, and you have to educate the doctor about what cancer is and how to what the tests are for it. The patient has to educate the doctors. That's the entire inversion of the system over here. You've got an isolated population, a vulnerable population because of impaired autonomy and decision making, and they're being experimented on without IRB approval with this new quasi-judicial role and we need IRB review. So with that, that wraps up my daily update regarding what's going on with the California Board of Psychology. So on December 29th through the 31st, I will be discharging or attempting to discharge my duty to protect and 1.05 obligations into the documented record. Because the California Board of Psychology refuses to accept discharge of duty to protect and 1.05 obligations, and instead seeking to sanction me because I was truthfully critical of self-proclaimed experts in parental alienation, a made-up, fabricated pathology. And they're claiming that the APA ethics code is not relevant to my defense. 1.05, 1.04, and 1.5, they're saying are not relevant, even though I am required to meet them. I can't use them as a defense for my criticism. They're saying the DSM-5 is irrelevant, So they can introduce this made up, fabricated pathology, and I can't defend myself that it's made up. It doesn't meet 2.04 because of that. And no, I can't use the DSM-5 as established knowledge. And I can't use the truth of my allegations or my criticism when I believe there may have been ethical violations. I can't use the truth to defend my criticism in absolute direct violation of due process. The truth is a defense. That's like constitutional rights under, Amendment 1, free speech. The truth is a defense. Okay, so I talk with my AI, and they're saying basically if the opposition motion is granted, this is a appellate. You appeal it because due process has been denied to me. If the truth is not relevant, I can't defend myself, and so I'm denied due process on that. So it'll extend for another 6 months, 18 months as we go into the appellate process. I'm self-representing. Oh my gosh, I'm going to have to learn all this other stuff. I want it to end. I want the state licensing boards to accept their obligation to protect the children and parents in the family courts and to enforce ethical standards then I'm good. I don't need to criticize everybody or anybody. But until somebody accepts my discharge of duty to protect, I still hold it. And so I'm putting my career at risk for the parents and children and for professional integrity. And if they sanction me, well, then we take it the next step and we continue on with this, because children are being abused daily without diagnosis, without treatment, without protection. And it's creating substantial devastation to the children and their parents and the court's decision making. So with that, good luck, everybody. I'll check in with you, and stuff is still coming. So I'll check in with you tomorrow and keep you informed of what's happening in the family courts.